the sources. And I believe that as we make progress, you understand better what we are doing. So once again, I would like to welcome. Okay, so right away, we look at case law as a source of Nigerian law. And when we talk about case law as a source of Nigerian law, the other name that is called is judicial precedent. And under this topic, we will look at the meaning of judicial precedent or case law. And we'll also look at another term known as the ratio decidendi. Is a Latin word, and obiter dictum. Obiter dictum is also another Latin word. So we will look at the essential operation of the case law and how it affects the hierarchy of courts in Nigeria. I believe the word hierarchy will not sound strange to all of us. I won't explain in our previous classes that the structure of the Nigerian legal system is hierarchical, meaning that it's in strata, it's in levels. Just the way we have the Supreme Court, which is the highest court in the land, we also have the Court of Appeal as the second in command, and it trickled down to the smallest court in the country. So, to start with, like I said earlier, the topic is the sources of law, and we're looking at case law or judicial precedent as a source of Nigerian law. So, the first thing we will first of all look at is the meaning of precedent. What is a precedent? And the word precedent can mean so many things, and depending on what we want to establish per time. So the word precedent connotes several connotations. I mean, talks about several connotations because there are precedent in conveyancing, in pleadings, but our major focus as we speak is on judicial precedent, that is case law. So what we mean by precedent is something that has happened before, that has set a standard or like a format to other things that we follow. If maybe I'm looking for the simplest example that I can give to explain this. If, for example, all you need to do as a student is just to attend classes, and then whether you write the exam or you don't write the exam, you'll be giving your certificate at the end of the day. And let's say it has happened for year one, people come, just attend classes and go, and they move them to next level, even without writing an exam. The same thing happens again next year. The next year that comes to 200 level move forward without writing an exam. So it will be said that those in 200 level have set a precedent that they don't need to write exam. All they need to do is to attend classes. So that's what we mean by precedent. And precedent can be in different ways and come in different ways. But the focus that is what we're focusing on is judicial precedent as a source of law. And a precedent, as we can define in this class, is an earlier event or action that is regarded as an example or a guide to be considered in similar cases or circumstances. So that is what precedent means. It is simply an earlier event or action that can serve as an example or a guide to a subsequent similar cases or circumstances. And it has been defined severally in different judicial fora by the court, and even sometimes the law report that gives the report of the transactions of court have also shown that the definition is similar in form and in content. So the meaning of judicial precedent is based on a Latin maxim. Latin maxims are sayings, let's simply say sayings in Latin. Okay? And the Latin word for it is stare decisis et non quod mavor. Though the spelling may be something of contention, but it is a Latin word. I'm trying to activate.
Okay, can you make me a host so I can share my slide?
So that you can be able to get the spelling as it displayed on the screen. So the Latin word for it is stare decisis et non quieter mover. And it simply means to stand by what has been decided and do not unsettle what has been established. That's what this is simply about. That stare decisis or judicial precedent means simply that you stand by what has been decided and do not unsettle the established. Now, let me explain this to us in a simple language, because we are not law students, so that it can be, clear and simple enough for us to understand. So what we are saying is that if there is a case before the court and the court has decided one way or the other, what judicial precedent simply means is that the decision of that court as reached in that case becomes a source of law for subsequent cases that may have similar facts. That's what we mean by doctrine of stare decisis or case law. And that's why you often hear in court when lawyers will when lawyers cite cases, they will say in the case of X, X, and Y. So all of that is to show to us that a case that the court has decided before now becomes a source of law that can be applied to another or subsequent cases. So all of this is simply what we mean by judicial precedent, and the court also embraces it because it's more like the way the court makes law. Okay, so that's basically how judicial precedent can be explained, in simple terms. It's simply the decision of a court in a matter that has been done before, either by higher court, which is applicable to subsequent cases that we have similar facts. So, having said that, we now move on and we look at how the judicial precedent has become a source of Nigeria law. Okay, so in doing this, we will look at the nature of judicial precedent. That is, what is the nature of judicial precedent? That's another subtopic that we will take, which will further broaden our understanding on this particular subject that we are looking at. So, talking about the nature of judicial precedent, when a dispute arises, it may be brought to court for determination. At times, the dispute before the court may be what interpretation to give to a particular constitutional provision, which the people who brought it are not sure of the meaning. So parties on both sides then call their witnesses one after the other. They testify. And on conclusion, the judge sums up the facts, addresses himself to the facts, and apply the law to them. And that's when the judge gives a judgment, which is also known as a verdict. So the process may be punctuated with preliminary matters of law, and the judge frequently has to rule on them as they arise. All these offer the judge the avenue to make authoritative pronouncement, which is judgment at the end of the day. So when we are focusing on the nature of judicial precedent, number one point we want to establish is that precedents are not made in vacuum, meaning that in arriving at a decision, the judge may adopt a deductive or inductive approach. He may look at the facts and then, before he can apply a certain rule of law or a particular law to it, and then pronounce a judgment. And the judgment will now, put the court in a position that can make it to make law for the country. Because whatever argument that parties have put before it, and the law that the court has applied to it, and the judgment that the court now pronounces, now becomes a sort of law. And that's why, even though we have said that usually it is not the court that make law, courts do not make law, but the truth of the matter is that when a court is giving judgments, usually the outcome of the decision of court are usually taken as law. Because like we said, if anybody now wants to bring a matter that is in the same fact, that decision that was reached in that court, that case, will automatically be applied to it. Meaning that the court will not have to go through the rigors of trying to find out how to judge the matter again. Let me use that word. But we simply apply the law or the decision that it has reached in that previous case to the case before it. And before a judge gives a judgment, the judge usually have reasons for its decisions. Okay? And the reason for the decision or the principle behind the decision made by the court is what is generally known as ratio decidendi. Ratio decidendi. I'll spell that again for the benefit of those who are writing. Ratio is spelled R-A-T-I-O. Decidendi is spelled D-E-C-I-D-N-D-I. So it's not an English word, but Latin. And that is what that is the Latin equivalent of reason for the decision. So that is to say that before a judge can give any judgment, he will need to provide the reason for the decision. And of course, that is still how what the nature of judicial precedent is all about. Meaning that there is no judgment that comes into being without the court considering fact and the law to make a judgment. And when the judgment is made, the judgment then becomes a law that is applicable in subsequent cases, as the case may be. So ratio decidendi is the reason that led to the decision, and the ratio decidendi, that is the reason, forms the legal principle, and it becomes a binding precedent that must be followed in future cases containing similar facts. So again, like I said, ratio decidendi simply means simply means a proposition of law which simply means the reason for the decision, and that's another way to look at it. And it has also been described as the principle of law on which a judicial decision was based. So that is to say that judicial decisions are not automatic, and if they are not automatic, they are based on the fact of the case and the law that is provided before the court. So, and it is the point, ratio decidendi is the point that determines the judgment or a ruling. And like I repeat again, it is made up of material facts, that is the story of the case, and the law that the court applies to it in order to arrive at a judgment. Also, apart from the ratio decidendi, there is another important thing we need to consider, which is known as obiter dictum. Obiter dictum. Obiter is spelled OBITERDICTUM. This is another point, another word that we consider under the nature of judicial precedent, because we have said that judicial precedent is a case law, and that case law is the judgment that court gives in a particular matter. And we went further to say that, going by the nature of judicial precedent has its own nature, which is that it is gotten from the facts of the case presented by the parties and the law that the court applies to it to give a judgment. And that's why we talk about ratio decidendi. The ratio decidendi is now the reason behind the judgment the court gave. So that is to say that before a judge can give a judgment, the judge must have the reason for that judgment. So, in addition, we're now talking about obiter dictum. What role does this obiter dictum play in determining the nature of judicial precedent, or the nature of precedent or judicial precedent, as I've said earlier? So, what is obiter dictum? Obiter dictum is a Latin word meaning by the way or in passing. It can simply be said that obiter dictum are statements made in passing, which does not form the reason for the decision. As we are speaking now, we are teaching now, sometimes we digress. Sometimes we make examples. Those examples are not the lectures themselves, but they are the things that will make you to understand the lecture that we are having. So, therefore, it's also present in judgment too. That why the court is making his reason for the decision, he can make some statement by the wayside, which is like to further buttress the point. For example, in a particular case, which happens to be that an individual bought a ginger beer. Let's say you bought a beer now and you drank it, and after you've taken it, as you were taking it, you now discover a decomposing substance inside, meaning that that thing was not properly packaged, meaning that those who produced it did not take reasonable care to produce it, and they now produce something that is contaminated. So the question that was before the court was whether the manufacturer of that ginger beer, whether it has a duty of care to the final consumer. Because let's take, for example, those that produce Coca-Cola. We are not always there when they are producing it, but they have a duty to prepare to produce it in an hygienic environment, that it will not in any way be injurious to us. Because if they produce it in an environment that is not healthy, it can affect those who drink such at the end of the day. So the question in that case was whether the manufacturer of that ginger beer has a duty of care to its final consumer. And the court answered and said yes. But while the court was going to write the judgment, the court talked about and brought about what they call neighborhood principle. Because you are supposed to show your neighbor love, or you are supposed to do unto your neighbor as you want someone to do to you. So the question is, if that ginger beer was manufactured in Ibadan, the person who drank it and discovered that the thing has decomposing substance is now in Lagos, how can the man in Ibadan and the company in Ibadan and the man in Lagos be neighbors? So court said by way of obita that your neighbor in law is anybody who will be affected by your action. It's just like you are on the highway, you are driving. You are not considering those who are moving on the road. But the law says that those who are moving on the road with you, they are your neighbor, because whatever you do may affect them. So court said that by the wayside before it went to hold that indeed the manufacturer of the ginger beer has a duty to ensure that it produces the substance in the most ideal way that will not bring harm to anybody. So that is how obiter dictum is, even though that is not the reason for the decision that the court had or gave, but the court said it just by the wayside. So, like I said earlier, any other pronouncement on law in the course of a judgment is an obiter dictum. That is, statement by the way, and it does not form part of the ratio decidendi. Okay? And as you can see, also note is that examples of obiter dictum are explanations, they are analysis, they are illustrations, even opinion, explanation, suggestions, and observation. You realize that sometimes when we are teaching you, we make references to different things, all because we want to look for the best way to pass the message across to you. So that is obiter dictum for you. Why ratio decidendi is the reason for the decision. Obiter dictum is the statement made by the wayside. So therefore, these two form a bulk of what is contained usually in the judgment. Okay? And indeed, where those two things are there, they become part and parcel of the judgment. And then they become precedent and to subsequent cases that will have similar facts in the future. So, having said all of this, having looked at the nature of judicial precedent, the next subtopic we want to look at is types of precedent. Type of precedent. There are basically two types of precedents. The first is authoritative precedent or decision, and the second is persuasive precedent. I said first is authoritative precedent. The second is persuasive precedent. A case may be binding on a subsequent case if both cases are materially identical. when a judge indicates that the case cited is not binding, he is saying that the material fact of that case and those of the present are different. And it comes to that conclusion by distinguishing both. So, therefore, cases or argument before the court usually contain facts, and the court will have to make a pronouncement based on the fact and the judgment itself. So, meaning that if that case is cited tomorrow and the court believes that it can be applied, then it is a binding precedent. But if it is not, then is the second type, which is persuasive. That is a simple judgment that can serve as a guide, but not that it must be applied to another case. So for what it's worth, just know that there are two types of precedent. One is binding precedent, while the other one is persuasive precedent. So therefore, that is what explains what judicial types of judicial precedent is. Then the question then we need to ask is, what are the advantages and disadvantages of case law or judicial precedent? There are quite a lot of disadvantages, and there are quite a lot of disadvantages and advantages. And by the time we probably finish these advantages and disadvantages, we may understand better what we mean or all that we have been talking about ever since the class began. So now let's look at the disadvantages. Number one is that judicial precedent or case law has the effect of limiting judicial discretion, meaning that the court may not be free to apply its own discretion because there is already a case in which the court must apply, especially a lower court. So meaning that if, for example, a case was decided based on fraud, that case will continue to be applied to other cases that the court want to apply it to. So that's one disadvantage, because of course, we hear a lot of things that sometimes that judges are bribed to be able to perverse judgment in the favor of the person paying the bribe. And if a judge has been bribed, he may not deliver the right judgment, meaning that if that judgment is now delivered, because it was not reached based on merit, it will continue to apply to several other cases, which may also lead to injustice. So another disadvantage is that it may even lead in some cases to a premature crystallization of rules, when in fact they were still only in a formative stage. In effect, the future and early development of law is slaughtered on the altar of history. So what that means is that sometimes rules that court formulate may need to grow, may need to have been tested in several cases before they can now become a law. But in judicial precedent or case law, sometimes the principle may be reached, and then the next thing is that it's now being applied as a law, which on many occasions is not in the best interest of the community, because the said law is really yet to develop properly. Okay. Then also another third disadvantage is that a judicial error may be perpetuated until rescue comes, if at all, from the legislature and public opinion. Okay. What we are saying is that if an error is made and the judgment is now standing, the error in that judgment, if they apply that judgment to other cases, it is like continuing to apply the same error on and on and on, to subsequent cases. This is one of the disadvantages of the judicial precedent, that is the case law that we are looking at. Now, again, another one is that okay, another disadvantage. Okay, don't let me even bother us so much about the disadvantages. But of course, we have mentioned that it can limit discretion. That is, it cannot, allow the court to apply free discretion. But aside all these disadvantages of judicial precedent, it has its own advantages, which include that it saves time. It saves the time of the court. Apart from saving the time of the court, it also helps consistency, especially if the judgment was reached without any error, without any element of fraud. It means that if anybody brings that similar case before the court next time, the court will simply apply the judgment that was given in the previous case to it, and that will be the end. And there will be no need for continuous waste of time of the court. So again, and another advantage that can be said is that it saves time of the court. It also saves resources of the court in which the case is standing before. So this is a brief summary on the topic case law or judicial precedent as a source of law. So I would like to take questions on this particular topic before we call it a day. Let's take questions. If there's an area you're not clear about, we don't mind making further effort to explain this to us.
Good evening, sir.
Good evening.
Yes, sir. I'm sorry, I didn't understand the persuasive precedence. Please, can you explain that again, please?
Okay. Maybe I should try to simplify the precedent itself. Let's say, for example, you, Mr. Israel, you took Mrs. Egypt to court. You took Mrs. Egypt to court because Mrs. Egypt collected 5,000 naira from you to supply 30 crates of eggs. Okay? I hope you are following me, or you just ask the question and disappear.
Yes, sir. I'm with you, sir.
Okay. So the person collected 25,000, and he was supposed to supply you 30 crates of egg. Even though I know that some people in this class will be wondering that How will 5,000 naira bring 30 crates of egg? It may not be so at this moment, but I like to prophesy that it will still come to that in a time of this country where 5,000 naira will buy 30 crates of egg. So those who believe and have similar faith with me
Amen.
can say amen wherever they are.
Amen. Amen.
Okay.
Amen.
Amen.
Those that like egg are already saying amen.
In this Tinubu regime.
Amen.
Okay. So let me explain further. So Mrs. Egypt has collected money from Mr. Israel. And Mrs. Egypt now failed to supply the eggs that Mr. Israel paid for. And then Mr. Israel now took Mrs. Egypt to court. And the court now, where after they have put up their cases, after they have argued here and there, the court now said, because Mrs. Egypt has collected the 5,000 naira, she must go and look for the egg at all costs and deliver it to Mr. Israel, if that is the judgment of the court. If another matter comes up tomorrow, maybe Mrs. Yemi gave Mrs. Sarah 5,000 naira or 6,000 naira to go to supply 20 liters of petrol. And after Mrs. Yemi has given Mrs. Sarah that money, Mrs. Sarah refused to deliver the 20 liters of petrol. If they take the case to court, the court is likely to look at the case that was decided in Yemi and Egypt and said, because it is of the same facts, Mrs. Israel gave Egypt money to supply. He collected the money and did not supply. Court, that judgment in Israel and Egypt has become a precedent, which can be applied in a similar case of Yemi and Sarah. So, if the lawyer to Yemi now cites the case of Israel and Egypt, that in that case, the court held that once you have been paid for something, you must deliver it at all costs. That case, that authority becomes a binding authority, meaning that the court that is handling the Yemi and Sarah's case, if it's a lower court, must follow the same pattern, must give the same judgment. So that is a binding precedent. But the one that is the persuasive precedent, which is the second type of precedent, is this. If in the course of determining the case between Israel and Egypt, the court now says some things in the process and said, is it that this Mrs. Egypt does not know that once you collect money from somebody,
Go to Yatoland
you must
shop. Let me collect my charger. So we are climbing more. Just let me go and collect something. They send you message.
So you now said that Mrs. Israel should know that, Mrs. Egypt should know that Israel is our neighbor. That that thing that she did is not so very all right. That statement was said by the wayside. So that if again another case comes up, that kind of a statement made by the wayside cannot be enforced on that case. But unlike the first analogy we gave, where the judgment of the court in the first case is now applicable to this, and the court that is now handling the new case does not have any choice but to apply the case. So that is the difference between the persuasive and the binding precedent. Yes, any other question?
Yes, sir. I have a question.
Well, Mr. Israel, I hope we were able to
Yes,
answer you.
yes, sir. Yes, sir. Thank you, sir.
Okay.
You just have to explain that authoritative or binding precedence and the persuasive, which I wanted to ask first. Then the second one is the disadvantages. I
Please,
think
can you speak up a little? I can barely hear you.
yes, sir. I said you just made justice to that authoritative or binding precedent and persuasive precedent, which I wanted to ask at first. You just made justice to that. But my second question is just for you to and repeat yourself again on the disadvantages. The disadvantages of the case law. I didn't get it. I am actually
Okay, you are saying that I should repeat the disadvantages?
yes, sir, because I'm actually taking your notes. So you were just a bit too fast. And
Okay.
I got lost along the line. Thank you, sir.
Okay, so I said number one is that judicial precedent or case law has the effect of limiting judicial discretion. And I said because the lower judge cannot apply discretion. He will need to apply the decision that the court has given earlier. That is the issue with that. That's number one. Number two is that it may lead to a premature crystallization of rules when in fact they were still only in their formative stage. They ought not to have become something that they can be applying. That that judicial precedent can aid such to now become a principle, which again may not be in the interest of people. And also, we made mention of another disadvantage that says that a judicial error may be perpetuated until rescued, meaning that if the judgment was reached in error, it will continue to be applied in error until either the legislature changes it. So those are the few disadvantages that we gave. So let's give another person room because I must end this class in another 2
Hello,
minutes.
sir.
Yes, please. Yes, I can hear you.
Hello, sir. Hello.
Please go ahead.
Okay, sir. Sir, thank you for this evening lecture, sir. I enjoyed the lecture completely. I would want to ask something. Is there any technicality in law by which a judge of a lower
Hello, sir. Hello.
court can set aside a issue in the past? If the Supreme Court had given a verdict on such an issue in the past, the decision was wrong. Is there a way a judge in a lower court can set aside that in that kind of, and he has to apply judicial precedence? Is there any way he can set it aside by technicality?
No. You cannot do that.
No way.
No way.
All right, sir. I'm enjoying your class, sir. That's right. Well done, sir. Thank you, sir.
Thank you.
Hello, sir.
Thank you so much. Yes,
Hello,
please.
sir.
Yes.
Yes, sir. You said is safe resources of the court in which the case is. I don't understand the advantages, sir. Please, can you come again with the advantages of judicial precedent, sir?
I said it saves time and also helps in a quick disposition of cases. I can't really remember the exact thing I said before. I said it from my head, but I said judicial precedent saves time and it also brings about certainty, meaning that if a particular element is given for one reason, if the same reason comes tomorrow, it is also applied. So that is a certainty, meaning that they say, that was the way Amechi was sacked, because this was what he did. Now that this same person has done the same thing, this person is also likely to be sacked because there's also already a case law or judicial precedent that has handled the same. Okay? All right,
All right, sir.
so
Hello, sir.
let's
Hello,
let
sir.
me just take that
Hello,
woman
sir.
and then we'll
Hello,
close.
sir.
Hello, sir. Good
Hello,
evening.
sir.
Let's take
Good evening,
Jennifer
sir.
Augustine.
Good evening, sir.
Yeah, good evening.
Okay, a quick one. Your explanation on the authoritative precedent and persuasive weren't clear. It seems you mixed up the both together. I couldn't differentiate between the persuasive and the authoritative. Can just take of your
I
time.
said the binding, you must apply it. You must apply it. But the persuasive is that you are not bound to apply it, especially if it is not more like a judgment given by the higher court, but it can only serve to give you an explanation, but you are not bound to apply it because it does not form the reason for the decision. For example, if obiter dictum or statement by the wayside is made, that can only help you in a lower case to reason, not to apply it, that you must apply it. It's different from ratio decidendi, which is the reason for the decision, which has now turned to a judgment and a case and a law that you must apply at all costs. I'm sure when you listen to this class again online, because the class is recorded to the YouTube platform, you will understand what we have said so far. So I'm glad that we've been able to take one of the sources out. By the time we meet again, by God's grace, we will cover more ground. So I want to thank you once again for joining, and then
Hello,
we'll
sir.
meet some other time. Thank you very much and enjoy the rest of the day.
Yes, sir.
Thank you very much, sir.
Thank you, sir.
Thank you.
Thank you very much,
Thank
sir.
you, sir.